पसंद है?
Yes, ma'am.
Okay. What's the importance of constitution in India?
Ma'am, constitution is the fundamental body that governs the entire Indian nation, ma'am. It also tells the how a government will run the country. It also talks about the rights of the citizens. It also tells about the limitation that is being put on the government of India.
Okay. किस पार्ट में या कहां पर गवर्नमेंट की लिमिटेशंस बताई गई हैं कॉन्स्टिट्यूशन?
Ma'am, there are various parts. For example, if there is any policies which violate the fundamental right of citizens, you can approach to the Supreme Court under Article 32 and High Court under Article 226. So this is the limitation which I feel this given Constitution. Also, there are various specific limitation that has been also given in Constitution. For example, Article 19, where a state can impose reasonable restriction, and under Article 21, that if a state want to deprive anybody from his personal life and liberty, then that has to be in accordance with the procedure established by law.
Okay, what the meaning of procedure established by law?
Procedure established by law, ma'am, simply means procedure which is flow from a specific process that is reasonable, that is not arbitrary, that is very certain.
Here it is mentioned that procedure is reasonable, non-arbitrary.
Ma'am, it is not mentioned in somewhere, but the Supreme Court came up with this interpretation in Menka Gandhi case in 1978, ma'am.
Okay, 1978. So, क्या बोला मेनका गांधी के केस में ऑनरेबल सुप्रीम कोर्ट ने?
Ma'am, Supreme Court in Menka Gandhi interpreted Article 21 and has held that the procedure established by law under Article 21 should be reasonable and fair in nature. So whatever the law from which if a state wants to curtail the liberty and freedom of individual, that has to be certain, that has to be reasonable, that has not to be arbitrary in nature.
Okay. इससे पहले क्या कोई केस हुआ था जिसमें बोला था कि each and every law made by the parliament is sufficient enough to curtail the life and personal liberty of person?
Ma'am, before that I can recall that in 19
बहुत ही strict interpretation Article 21 की कर दी.
Yes, ma'am. There was I think I'm not able to recall the case, but in 1951 I think A.K. Gopalan was the case.
Yes, it's A.K. Gopalan.
That said, the fundamental right are act as in silos and they are not interconnected. That is a very narrow interpretation given by Supreme Court then and there.
Okay. अच्छा ये बताइए कौन सा ऐसा आर्टिकल है इंडियन कॉन्स्टिट्यूशन का जिसका इंटरप्रिटेशन सबसे लिबरल किया गया है बाय ऑनरेबल सुप्रीम कोर्ट?
Ma'am, I think it's Article 21 only, ma'am.
It's Article 21. Why? क्यों ऐसी आवश्यकता पड़ी कि Article 21 का इतना लिबरल इंटरप्रिटेशन करना पड़ा?
Ma'am, because the word uses the word life, so whatever ancillary and the supporting things that sustains life has to be fall under the ambit of Article 21. For example, a right to clean environment, right to clean water, right to treat it with dignity. All are treated to all are has to be taken as a part of Article 21.
Okay. Do you know a case in which Honorable Supreme Court held that right to life means right to life with choice and dignity?
Ma'am, I think I know, but I'm not able to recall. I think it's the Aruna Shanbok case.
Oh, ये तो अभी है, इससे बहुत पहले की बात है. फ्रांसिस कोरेली का केस सुना है आपने कभी?
Ma'am, which case?
फ्रांसिस कोरेली.
Ma'am, no, I'm not able to recall that.
कोई बात नहीं है. So उसमें Article 21 को इंटरप्रेट करते हुए right to life means what type of life? So Honorable Supreme Court ने कहा the life means right to life with choice and dignity. ऐसी लाइफ की परिकल्पना, ऐसे जीवन की परिकल्पना भारतीय संविधान करता है जो विद चॉइस हो, जहां लोगों के पास विकल्प हो एंड लोगों की गरिमा हो. तो ठीक है, जितना भी आर्टिकल 21 का लिबरल इंटरप्रिटेशन हम आज कर रहे हैं, दैट्स बिकॉज ऑफ दैट केस, बिकॉज वहां पर लाइफ को बोला लाइफ विद चॉइस, है ना. आज है ना आप किसके साथ मैरिज, किस फील्ड में एजुकेशन, कौन सा प्रोफेशन, कौन सा ट्रेड, क्या करना चाहते हैं, ये विद चॉइस और विद डिग्निटी की बात आती है. खैर, आपने भी अरुणा चांद बेग जजमेंट का नाम लिया.
Yes, ma'am.
Okay. Why this case is so important?
Ma'am, because it laid down the ground for the foundation of passive euthanasia in India. It was the first case where Supreme Court said that the passive euthanasia in exceptional case can be possible. After which final law was laid down in Common Cause versus India in 2018, where Supreme Court said that passive euthanasia in India can be allowed in under special circumstances, and also has laid down the guidelines for the same.
ठीक है. अच्छा ये बताइए आप न्यूज़पेपर पढ़ते हैं?
Yes, ma'am.
अभी इस समय इंटरनेशनल वॉर लाइक सिचुएशन चल रही है, किन कंट्रीज के बीच में है?
Ma'am, it's between Ukraine and Russia, ma'am.
ओके. इसका इंडियन इकोनॉमी या हम कहें कि बायलैटरल रिलेशन बिटवीन इंडिया एंड रशिया, क्या इम्पैक्ट इसका कुछ पड़ेगा भारत के ऊपर?
Ma'am, between India and Russia, there will not be a direct impact. However, India is under the present circumstances reeling under pressure from the West, so as to pressurize Russia or President Putin to stop the war.
Who will pressurize? India.
India, America is basically West nation, and US is asking.
India will pressurize the Russia. So there are so many things on which we are dependent somewhere upon Russia, like defense sector, oil. So it will adversely affect India.
Yes, ma'am. 55% of the arms comes from Russia.
Are you sure? Are you sure कि India will pressurize Russia? या India का एक non-aligned status रहेगा, जो कि हमेशा रहता है?
Ma'am, that is there, definitely that is there. But what I'm saying is there has been asking us indirectly that because India is the only nation that has a democratic setup and supports the Russia. So that is a kind of conflict of situation because we have the policies of the West and we are still friends with the Russia. And till date, India has followed the policy of non-alignment.
Okay. अच्छा, यूक्रेन पहले क्या रशिया का हिस्सा था?
Yes, ma'am. It was the part of the Soviet Union. In 1991, it got disintegrated.
Okay.
And got independent.
At that time, what was the status of India?
Ma'am, India was the independent nation. It got independent in 1947. However, the policies got changed. Since after 1991, we had the similar policy with Russia, and now Ukraine was independent democratic nation. So,
चलिए खैर, ये बताइए आपका सब्जेक्ट्स हैं टीपीए, कमर्शियल, कॉन्ट्रैक्ट एंड टॉर्ट.
Yes, ma'am.
ओके. आप टीपीए के बारे में बता सकते हैं कि टीपीए में ट्रांसफर ऑफ प्रॉपर्टी एक्ट फर्स्ट, वेदर द ट्रांसफर ऑफ प्रॉपर्टी एक्ट इज कंप्लीट कोड ऑन ट्रांसफर्स और नॉट? मैं रिपीट करूं, मेरा क्वेश्चन था अगर आपको कोई प्रॉपर्टी ट्रांसफर करनी है, ओके, वेदर टीपीए इज कंप्लीट और एग्जॉस्टिव कोड टू गवर्न द ट्रांसफर और नॉट?
Ma'am, in strict sense, the answer is no, because the transfer of property only tells how a transfer of has to be made. But there are ancillary acts which requires supplementation of to the transfer of property act. For example, registration act, which is done under the separate act. So I think transfer of property is not a complete code in itself. You require a supplemental act to be.
सेक्शन आपने जो बोला यही आपको जस्टिफाई करता है. There is a section 4 under transfer of property act, है ना, which says the term related to contract, जो भी कुछ Indian contract act में, like whenever it is mentioned contract, then we will have the same meaning, which है ना. So Indian Contract Act and Registration Act की help के साथ ही property can be transferred. So definitely TPA is not the complete code. Okay.
Yes, ma'am.
What do you mean by inter-weavers transfer?
Ma'am, inter-weavers transfers means transfer between the living individuals.
Okay. So whether transfer of property act govern inter-weavers transfer or other methods के through भी?
Ma'am, transfer of property governs transfer between the two living individuals or entities, because Section 5 is very clear on this.
Okay. ठीक है. ये बताइए, right to way is the movable property or immovable property?
Right to way.
Yes.
Ma'am, it's very abstract in nature, right to way. Right to way is, I feel it's a easement, right? So So a right to way in itself is not a transferable property unless the property itself is not attached with right to way. So an easement cannot be transferred under section 6 apart from the dominant heritage, I think.
ठीक. सो आप क्या इसे क्या कंक्लूड कर पाएंगे आप राइट टू वे? देखिए, जब आप जूरिस्प्रूडेंशियल एसेंस पढ़ते हैं तो प्रॉपर्टी केवल मूवेबल एंड इमूवेबल ही नहीं होती है, देयर आर वेरियस राइट्स जिनको भी प्रॉपर्टी की तरह रिकॉग्नाइज किया गया है।
Yes,
ईजमेंट राइट भी एक तरह की प्रॉपर्टी है। सो राइट टू वे क्या हुआ हमारा, मूवेबल हुआ या इमूवेबल हुआ? आपके आंसर में आपका अभी जो आपने रिप्लाई किया इसी में आंसर है। अच्छा चलिए, राइट टू फिशरी, राइट टू फिशरी,
right to fishery, ma'am, I think it's a transferable right. I think there's a case on this.
आप इसको एक काम करिए, आप इन राइट्स को किसी भी बुक में जिससे भी आप पढ़ते हैं, जितने भी मूवेबल एंड इमूवेबल की लिस्ट है, या पीटी के लिए जरूर पढ़ते होंगे।
Yes, ma'am.
यस, बिल्कुल आप लोग पढ़ते होंगे, तो इसको आप जरूर इसको देखिएगा, है ना। इसकी लिस्ट को तैयार करिए। देयर आर सो मेनी केस लॉ लाइक राइट टू कलेक्ट सैंड फॉर ब्रिक पर्पस, ये क्या है? तो इस तरह से आपको बहुत मटेरियल मिलेगा, इसको आप पढ़िएगा। खैर, डॉक्ट्रिन ऑफ इलेक्शन,
Yes, ma'am. It is given in section 35 of the Transfer of Property Act.
ये बताइए जो डॉक्ट्रिन ऑफ इलेक्शन है इसमें द राइट टू इलेक्ट बिटवीन टू, ठीक, ये किसको अवेलेबल है? वेदर इट इज अवेलेबल टू परचेजर और टू ओनर और द पर्सन हु इज ट्रांसफरिंग द प्रॉपर्टी?
Ma'am, right to election basically is given to the person to whom property belongs, to either accept the offer or to reject it as a whole.
देयर इज अ कोटेशन जो बहुत यूज होती है आर्टिकल, ये सॉरी सेक्शन 35 के लिए।
Yes, ma'am.
बता सकते हैं?
No one can appropriate and reappropriate at the same time, I think.
ओके, ठीक है। मान लीजिए अगर वो बेनिफिट्स ले लेता है, वो डायरेक्टली कुछ नहीं बोलता है एंड ही कंटिन्यूअसली एंजॉयिंग दैट बेनिफिट, सो क्या इससे प्रिजम्पशन क्या निकलेगा? क्या उसने एसेंट दी है? क्या उसने रेक्टिफाई कर दिया उस ट्रांसफर को और नॉट?
Ma'am, the basic presumption behind such an act will be taken as the implied acceptance of doctrine of election. So it will be seen that though you are not said, but there is implied acceptance of doctrine of election.
What's the difference between vested and contingent interest?
Ma'am, vested interest is given in section 19 and contingent interest is given in section 21. In vested interest, the property is transferred absolutely. In contingent interest, it is not. It will transfer at the happening of some uncertain specified future event. In contingent interest, your transfer is perfect. It is ready. The only thing is that happening of particular.
So contingent interest may also convert into vested interest.
Yes, ma'am. For example, the transfer made in the favor of unborn child. The moment child is born is contingent. The moment the transfer made is contingent. At the time when the child is born, it becomes a vested interest.
Okay. ठीक है, ये बताइए कॉग्निजेंस क्रिमिनल प्रोसीजर कोड में who can take cognizance?
Ma'am, cognizance in criminal procedure code is governed by section 190. It is generally taken by the magistrate of first class, and second class magistrate can also take it when the High Court has specially empowered him to do so.
What is the meaning of cognizance?
Ma'am, cognizance has not been defined in criminal procedure code, but in the general parlance, it means a judicial acknowledgement of the charge sheet or the challan or the complaint, whatever the case may be.
Okay, very good. अच्छा ये बताइए आगे, अगर आप जज बन जाते हैं तो आप सिविल जज जूनियर डिवीजन बनेंगे।
Yes, ma'am.
सबसे अधिक मैटर आपके पास इंजंक्शन के आएंगे। आपको पता है इंजंक्शन क्या है?
Yes, ma'am. There are two types of injunction. One is temporary and one is permanent in nature. Temporary injunction is governed by the Civil Procedure Code, and the permanent injunction is governed by the Specific Relief Act.
ठीक है, मान लीजिए आपकी कोर्ट में इंजंक्शन के लिए अप्लाई किया जाता है, सो क्या वो फैक्टर्स हैं जिनको आप कंसीडर करेंगे बिफोर ग्रांटिंग दैट इंजंक्शन ऑर्डर?
Yes, ma'am. So basically, there are few factors which has to be kept in mind before granting injunction relief to a petitioner. First is that whether the balance of convenience is the favor of petitioner or plaintiff. The second is whether irreparable loss will be caused if injunction will not be granted. Also, if there is a prima facie case in the made in the favor of the plaintiff, which has approached the court.
Very good. What's the correct? Can you distinguish between balance of convenience and irreparable loss?
Balance of convenience, ma'am, simply it tells if the case in future would go to the court, then who is likely to win the case based on title, based upon the evidence, or based upon the document, whatever the petitioner plaintiff has at the moment. Irreparable loss means if at the present, if no relief would be granted to him, he will suffer a loss, and later on, if the case goes to the court and then the relief is given, then it will be of no value. So
Very good. Very good. अच्छा, बस एक चीज और बता दीजिए, इंजंक्शन ऑर्डर करते समय when you examine the balance of convenience, irreparable loss, etc., then क्या आप इसको मेरिट पर देखेंगे या प्राइमा फेसाई देखेंगे?
Ma'am, generally in granting injunction on the temporary basis, you see the balance of convenience in the start. For to go to grant injunction on the basis of merit, you need to pass a permanent injunction, which is kind of decree.
Very good. So you will just prima facie examine the matter.
In the case of temporary injunction, yes, ma'am.
Very good. Very good. काफी अच्छा है आपका बोलने की आपकी नॉलेज भी अच्छी है एंड बोलने का बस थोड़ा सा अब क्योंकि हम ऑनलाइन है तो हो सकता है आपका जो आई कनेक्शन है वो मुझे ऐसा महसूस हो रहा हो अभी जो नेक्स्ट इंटरव्यू